Welcome to Caregiver Counsel, Elder Law Insights with Tieesha Taylor.
Hello and welcome back to Caregiver Counsel, Elder Law Insights with Tieesha Taylor. Tieesha is the founder and CEO of the elderly care law firm in South Florida, where she provides compassionate, generational legal service to families navigating Medicaid, guardianship, probate, as well as long-term care. I'm Kevin Rosenquist, and today we're talking about two legal tools that can protect or sometimes complicate a family's future: the power of attorney and guardianship. We're going to look into what they mean, when they're used, and how to make the right choice before a crisis hits. Tieesha, welcome.
Thank you. I'm excited.
Yeah. So, obviously families hear power of attorney and guardianship. Those are terms that are thrown out around a lot, especially when you're getting involved in estate planning or Medicare or what have you. Can you start by just explaining exactly what power of attorney and guardianship means and how they differ?
Sure. So a power of attorney is a document that a loved one will sign based on their own knowledge. So they're competent, they can sign a document, and they can express their wishes on who they would like to act on their behalf. So the power of attorney document, it lets someone that they trust help with things like paying the bills, helping with property taxes, any benefits, or Medicaid planning. So it allows someone to step in to help someone who needs assistance. So it lets someone step in and help them when they need assistance. Now, a guardianship, on the other hand, happens only when someone can't make decisions safely and they did not have documents in place like a power of attorney. So the family typically will then have to ask the court to appoint them as guardian. So the power of attorney means the loved one chooses, and the guardianship means the court chooses who will make decisions.
Okay. Oh, that's a big difference.
Yeah.
Do you find that people are surprised when they aren't automatically the person, if you will? Because I can imagine a lot of people, a lot of caregivers, if they're taking care of their parents or whatnot, just assume that they have that power already.
Yeah, we get those clients all the time who come into our office and they'll say, you know what, I'm a child or I'm a spouse, and
Spouse,
I
yeah.
should be able, yeah, spouses especially, they'll come in, I should be able to access my spouse's bank account. We have clients come in all the time. Maybe a spouse had a stroke, or they can't make decisions, and they were the only person named on a bank account. And so a spouse comes to us and say, we need access to that bank account. But banks, hospitals, and some agencies, they may not speak to family members, even a spouse, without legal documents like a power of attorney. So, of course, a lot of caregivers are shocked to learn they can't sign anything or even access accounts without the right paperwork in place.
Yeah, that's a tough situation, obviously, too, because, you don't, if you don't know, you don't know what you don't know. Right. And if people aren't aware of that, that's can put them in a really difficult position when they have to react to a situation that happens.
Yeah, that's right. Yeah,
Mm-hmm.
a lot of times they will come to us and they would think that they have access because, and like I said, a spouse in particular, well, I'm married to this person. They're my
Mm-hmm.
spouse. I should be able to access their account. But banks, have to abide by certain laws, and they can't just give access to someone if their name isn't on the account. So a lot of caregivers are in those complicated and difficult situations.
And you understand from the banks and the hospital perspective, there's too many legal ramifications. They gotta go by what the letter of the law says.
That's correct.
Yeah,
Yes. Right.
no
Yeah.
doubt. So is there a point where perhaps a power of attorney stops being enough and a formal guardianship becomes necessary?
Yeah, so I would say there may be a few instances where the power of attorney may not be enough. One of those, and this is pretty common, is when children are fighting. So they're fighting amongst each other. Siblings cannot get along with each other. And so one person wants to make a certain decision for their parent, another child wants to make the other decision. And so there's a lot of conflict. So in that case, we may have to proceed with guardianship sometimes. Another situation is when maybe the elder is being exploited by the person who is listed in the power of attorney document. So there are certain actions we must take to make sure that they're not being exploited or they're not taking advantage of the elder by using a power of attorney document. And another one, I would say, maybe a lot of people will print off power of attorney documents online. And so they'll come to us where we're elder law attorneys, and they'll say, for example, we want to get Medicaid planning for my mom. And we'll say, well, tell us about mom. Mom may have dementia and can't make decisions, so she can't execute another or sign another power of attorney document. So then we take the next step and say, do you have a power of attorney document in place? They'll provide us with the power of attorney document that they printed offline. And it doesn't allow for certain rights like Medicaid planning or creating a trust and other things that would help with long term care. So in those situations, we may then have to get the court involved if we really need to proceed with things like Medicaid planning or making healthcare decisions. So those are instances where the power of attorney is not enough.
Okay, that makes sense. Yeah, you see sometimes those stories of people taking advantage of older people. It's so sad. It's just
Yeah.
so sad that there's just some bad people out there.
Yeah, it is, especially in Florida, because we have a huge aging population. So we
Sure.
see it frequently.
I'll bet. I'll bet. Yeah.
Yeah.
Yeah. So are there different types of powers of attorney that families can get through Florida law?
Yeah, so Florida mainly uses what we call a durable power of attorney. And the key is adding right wording. So there must be certain wording within the durable power of attorney. Like, for example, if we need to conduct Medicaid planning, like I discussed earlier, or sell property or access online accounts. And the Florida durable power of attorney, there are certain rights that the person has to initial next to in order for it to be effective. So in Florida, we will typically use the durable power of attorney, and we help families, choose the right powers. So if a senior comes to us or elder comes to us, we will help them determine which rights they want to give, for example, to their children, so that they can use it for the next 10 or 20 years.
Okay. Do people have a hard time sometimes knowing which one is the right one for them?
They do. Sometimes they'll have difficulties understanding which ones they should choose. We'll walk them through it. And I'll give you an example. One right that a lot of families find difficult to choose, like the right to change beneficiaries on like accounts or beneficiary designations. That's something that families or an elder who comes to us, they'll say, well, what does this mean? Can the person who's helping me change a beneficiary designation? Some people would love to allow their children to do that. And others are like, no, we don't want that to occur. So there are some instances where find it difficult to choose what to do. Another one is having access to digital accounts. So passwords like on Facebook or other social
Hmm.
media. Those are rights, that they kind of second guess or try to determine whether or not they should allow someone else to step in and help them with.
I think guardianship can sometimes get a bad reputation because of how it could possibly limit someone's rights. So what safeguards exist in Florida to protect seniors from either unnecessary or perhaps even abusive guardianship?
Yeah, I know there are movies out there regarding guardians taking advantage of seniors, which it
Sure.
does occur. It does occur. However, Florida does have certain safeguards in place. For example, they do require medical evaluation. So, in the guardianship process, three medical professionals will go out to examine and create an evaluation to make a determination. The person who may require a guardian also is given an attorney. So they have an attorney who was assigned to them who could assist them and advocate for their rights. And it also forces courts to consider what we call less restrictive options before a guardian is even appointed. So, for example, a power of attorney document is a less restrictive option. Also, a trust or a healthcare document is less restrictive. So the court must determine if there are less restrictive options before they appoint a guardian. And then, of course, guardians are held to a high standard. They must file annual documents with the court. The other family members receive notices about major decisions, and the court can remove a guardian who is not acting properly. So that's something that is available in Florida.
Yeah, that's interesting that the other family members get notified of the decisions. That seems like a really good check and balance as well. Because if anyone's going to know that someone's being taken advantage, it's other family members. I would think.
Yeah, absolutely. Yeah, because
Yeah.
we'll get calls and they'll say, "Hey, I noticed that, mom hasn't been, eating properly," and so the guardian is responsible for that person. So the family members can go to the court and ask for some sort of relief and make sure the guardian is doing what they're supposed to do.
Are there warning signs that you've seen in your experience that a family might be heading towards a guardianship dispute, and do you have any tips on how to prevent that?
Yeah. So, of course, warning signs include when you see siblings in conflict. That's a
Yeah.
major one that we see.
Wait, siblings can be in conflict? I don't understand.
Right. Exactly. Exactly. That's one of the top ones that we see are siblings in conflict. The second one is disagreements about money, and whether that's, the parent is not managing their money, they're not paying their mortgage, or not paying their utility bills. So and they find that checks are being written to someone else. So that will a lot of times lead to a dispute or conflict. And then something underlying is like the secrecy about who is helping. If everyone is like a they if they just have the discussion with their parents and each other, but when there's secrecy involved, that's when it could be heading to some
Mhm.
sort of dispute. And then confusion about who's in charge. Some children think, oh, I'm the oldest, so I'm in charge, or the one who's living with the parent may feel that they're in charge, and there are other siblings who are living out of town. So that's when you kind of know it may be heading toward a guardianship dispute. But families can prevent disputes by just talking openly, updating other family members about what's going on. And the elder or their parents can, prevent some of these disputes by planning in advance. If you plan early, list who you want to act on your behalf, then you could reduce the amount of disputes that can occur.
Are there situations where multiple people would be named to a guardianship?
Yeah, so in Florida, you can have co-guardians, and you can also have one guardian who will act on behalf of we call them the ward in Florida. Once they have a guardian appointed, they can have someone who act on their behalf for financial and property matters, so pay bills and make decisions regarding finances. And then another guardian can be appointed to make healthcare decisions, like where they should receive medical treatment, or what type of medical treatment they should receive, or they can act together. So Florida law does allow co-guardianships.
So in the situation that you said where one may be financial, one may be health related, are they not allowed to make decisions on the other stuff in that scenario? Like, so if you're the financial person, are you not allowed to make the healthcare decisions?
That's correct. Yes, if you're
Okay.
appointed as the financial guardian, then no, you cannot make the healthcare decisions, and vice versa. But they also have the option of they both act together as co-guardians on both financial and medical.
Do you recommend that? I'm just curious because it seems like it could help in some ways, for sure.
Yes.
It's
Yeah.
not, it's a heavy burden for one person, but
Yeah.
it could also cause problems. I could see if they disagree.
Yes, that's very common, and we don't usually encourage co-guardianships. But if if the children come together and they both want to become guardians, I would prefer that there be one guardian, and then they just notify the other siblings, let them know what's going on, communicate, because there
Hmm.
can be conflict. Because what if one wants to make a decision about where their parent lives? One may want them to live in one assisted living facility or nursing home. Another one may want them to live closer to them in another. So there could be conflict when there are co-guardians. So you're correct.
Yeah, I could see that. I know I'm named on my parents' stuff, and I have two siblings, and we have a good relationship, so I would obviously ask them stuff.
Sure.
But I could also see a situation even with us getting along well, where if I
Yeah.
make a decision they don't like, then that could cause a rift between us, and then all of a sudden other decisions are getting second guessed and stuff, and I could just see that definitely adding a bit of tension in a relationship.
It does. And it can add tension. I mean, I see it all the time where you see siblings who get along while the parent is healthy. And then as soon as the parent is no longer well, or they're dealing with an illness, the siblings, they have conflict. I mean, there's a lot of emotions going on there.
Yeah.
And so they have to make major decisions. And so there is some conflict sometimes when that occurs.
Yeah, there's watching a loved one kind of deteriorate, if you will, is not an easy thing to do. So definitely the emotions are going to run heavy on that, no doubt.
Yes, absolutely.
Do you find that in your practice, when people, careful planning with power of attorney and all that, just make a huge difference in avoiding court intervention and avoiding these conflicts we just talked about?
Yes, all the time. So when, for example, I had recently a son, he brought his father in to see us to discuss some documents, like a power of attorney document. He had early diagnosis of dementia, but he was able to make decisions. So his doctor felt that he could still make decisions regarding the power of attorney. Um, and we prepared that document. And so the son was able to step in to help get things situated with his account because he was having some issues with his account. The bank wouldn't speak to him. The insurance companies wouldn't speak to him. But once we put that power of attorney in place, the son was able to assist his dad. And so they were very grateful. In fact, he called and he thanked us. And now he can do things in a more strategic way instead of being reactive. He was
Hmm.
proactive. And so he was able to do things and put things in place so his dad can live out the rest of his years, at least in peace and knowing that his son is taking care of him.
How does the documentation or the proof, if you will, work? Do you have to provide the original power of attorney signed document?
So in Florida, you do not. A copy is just as effective as the original because let's just say, for example, someone has four different banks. We can't give the original to one bank. So copies can be given to each financial institution. And then that person who's named in the power of attorney document can then step in and assist, manage the bank account, pay bills, and whatnot.
Okay.
Yeah.
Okay. To finish us up here, I could see trying, as a guardian, as the person in charge, really struggling maybe to ensure that a loved one's dignity, their wishes are respected day to day. It's not an easy job. What
Yeah.
kind of advice do you give to anyone listening who might be in that position and might struggle with that?
Yeah, that's a great question. The first thing I say is include your loved ones in the decision making process as much as possible. So
Hmm.
even if they have a dementia diagnosis, I mean, um, keep their dignity by trying to include them as much as you can. They may not be able to make certain decisions, but attempt to include them. Keep their routines. If they have a certain routine, if you can keep that routine, I found that that's very helpful. And then, of course, like I said, ask for their opinions and avoid any unnecessary changes if you can. I know certain things may have to change, like some clients may have to go from living in their home to living in maybe a skilled facility. But as much as possible, try to keep things as normal as possible. And then communicate with your family. I can't emphasize this enough because a lot of
Hmm.
conflicts and everything occur when there's one or two people making decisions, but they're not communicating with their other relatives.
Yeah.
Just communicate with them, have an open dialogue. And I think that would really show a lot of dignity to the person they're all who they all love and they want to care for. So those would be my recommendations.
Such great points too, because it's easy. I think it'd be easy to be in that position and, you know, not get power hungry. That's the wrong word, but just because you're like, I know I'm in charge of this, so I'm going to do this, I'm going to do that, and just not really thinking about that communication you were talking about, that keeping the loved one in the loop as far as what's going on. That makes a lot of sense.
Yeah, yeah, it does. And I mean, I know I got some people were like, well, they don't, someone who has advanced stage dementia, they may say, well, they don't know what's going on, but they may, they still have feelings, treat
Right.
them with dignity and still at least try is what I say.
Hmm. Yeah, I like that.
Yeah.
All right. Well, that's it for today's episode of Caregiver Counsel Elder Law Insights with Tieesha Taylor. If your family is facing questions about powers of attorney or guardianship, you don't have to figure it out alone. Visit elderlycarelawfirm.com to learn how Tieesha can help. And if you found this conversation helpful, please leave us a review, subscribe so you don't miss any further episodes, share it with anyone who can use it. Tieesha is here to help us. She's a wealth of knowledge. So Tieesha, thanks so much for being here. Really appreciate it.
Thank you. Appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.